Hi, welcome to the presentation today on how to protect your nest egg, wills, trusts, and the nursing home. I'm really glad you're here. And today I'm going to be talking all about estate planning and also focusing more specifically on planning for Medicaid because we get a lot of questions about that from people. And so that's why we decided to focus this seminar on that aspect of nursing home planning. So, first, before I get into the meat of everything, I want to just tell you a little bit about me. My name is Myrna Arroyo. I'm an attorney here in Baton Rouge. I've actually been practicing law since 1995. I graduated from Tulane University with an MBA JD. My law practice is focused mostly on estate planning, probate, Medicaid planning, although I do get involved with some business and tax issues and real estate as well, mainly because all of those practice areas kind of go together. Just to tell you a little bit about why I got into law practice is um, I've always been really interested in the whole concept of legacy and family and estate planning and how that all interacts, mainly because of an experience I had in my life. So when I was about 10 years old, my grandfather passed away, and um, and he left behind, his my grandmother plus my mother had us. There were seven of them total, brothers and sisters, one sister, the rest brothers. So can you imagine with that big of a family? He did not do any advanced planning, unfortunately, and he was an entrepreneur. He owned several real estate investments and several businesses in Puerto Rico, where I was born, actually, and where my family's from. So after he died, this chaos ensued. So immediately there were factions between the siblings. Some of them wanted to sell everything, some of them wanted to keep it going. Because he had left no clear plan, no clear succession, nothing was handled. It ended up resulting in a lot of litigation, a lot of family drama, and it really destroyed the family because there's a whole half of my mother's family that I never saw again after he died, and I find that really unfortunate. Um, so it took nearly 30 years to settle the estate, lots of litigation. My mom finally got her last distribution from the estate, maybe about 5 years ago. So literally over 30 years to get everything settled, if you can imagine. The expense and the stress of that litigation. So what I do in my law practice is try to help families avoid all of that by doing proper planning. And today we're going to talk a little bit about some basic estate planning concepts, and then we're going to go into more the long-term nursing home care aspect of planning. So I designed this workshop mainly for people who are concerned about long-term nursing home care. It's really one of the things that almost everyone that calls the office asks about. A lot of people are worried about going broke in the nursing home, and people generally, most of my clients really want to make things easy for their family if something happens to them. So that's kind of what we're going to talk about today. Where you're going to learn the basic elements of an estate plan. You're going to learn, kind of what the statistics are. How likely are you to need long-term nursing home care? Like, is this really something that you need to be worried about? How much does it cost here in Louisiana? And what kind of planning can we do to help protect your assets so that you don't go broke in the nursing home? So, what we're talking about today is proactive planning. So, we're talking about planning ahead so that we can design how we want things to happen as opposed to leaving things to chance. So, I have this great quote from this author, Alan Lacking. Planning is bringing the future into the present so that you can do something about it now. And that's really what you all are here to do. So, so what happens in Louisiana if you die without a plan? So Louisiana has a plan of intestacy. So there's laws in place that if you die without a will, the laws determine who gets your estate, how it's passed down, depending on you're married or single, or if you have children or you don't have children. These laws will dictate who gets your estate after you pass away. There's also laws that dictate what happens if you should have an incapacity and not have any kind of planning in place. Like, what do we do? So, um, if you don't like the Louisiana law version of what would happen in your case, then we need to put in an estate plan to prevent that. So the four elements of estate planning that I think are essential to take care of your family and your assets are listed here. So you're going to need a will or a living trust. Um, This is the document that's going to dictate how you want your assets to be passed down to your heirs. Whether you want to do that outright, whether you want to do that in a continuing trust, the will or living trust is really the first decision you'll make when you come meet with us. A lot of people ask, well, how do I know which one I need? And that's kind of what the initial meeting is all about with me, is to kind of help you figure out what's right for you. A will is not the best for everyone, neither is a living trust. Generally, a living trust is good for people that have more assets because it avoids the whole succession probate process. You can pass assets down to your heirs much more easily. But if you have a simpler estate and you don't have a lot of assets that would go through probate, a will may be perfectly fine for you. This is something that we talk about and we need to decide, case by case basis. It's not always better to do one or the other. The next thing that you really need is a power of attorney. If you don't have a plan for who's going to take care of your financial decisions if you become incapacitated, you end up in the very sad situation where your family basically has to file a lawsuit in order to get access to your bank accounts and to be able to manage your affairs. We get calls about this all the time where people call and they tell me, my dad is in a nursing home. I'm trying to help him, but I don't have power of attorney. What can I do? And unfortunately, once you lose capacity to contract, which under Louisiana law, you have to be able to be mentally able to understand what you're signing and what it does in order for us to say that you have capacity to enter into a legal agreement. So if you have dementia or Alzheimer's or any of those really horrible diseases that take away your mental capacity, then your family won't be able to just do a power of attorney. We're going to have to file an interdiction proceeding in order to be able to take care of your affairs. So that's super important. Healthcare directives are related, but they don't just cover financial matters, they actually cover your medical decisions. So we want to have documents that give the right people permission to make those medical decisions for you so that your family doesn't have to go to court to get permission to make a decision on your behalf. And then finally, if you're concerned about nursing home costs and you have the right financial picture that fits this, a Medicaid Asset Protection Trust can help you protect assets from the cost of nursing home care in the future. So I talked a little bit about, wills and living trusts and avoiding probate. So what is the probate process like in Louisiana? So Louisiana, we call it succession. We call it opening a succession when someone passes away. If they have a will, we file the will for probate. If they don't have a will, we just file the succession and ask the court to follow the laws of Louisiana to determine who gets everything in the estate. Whether you have a will or you don't have a will, you will have to go through probate. It can be slow. It's definitely public, and it can be expensive depending on your situation, obviously. I've seen some probates that go very smoothly because there's not a lot of errors, or the errors are all on the same page about what's going to happen. And, it takes us just a few months to process everything, sign the documents, and we're done. But then we've had some that take months, even years, and end up costing thousands and thousands of dollars, because when you open a probate, you open a succession, you're probably gonna have to hire an attorney, unless you have a super tiny estate. You're gonna have to pay executor fees. You're gonna have to pay appraisal fees. You're gonna have filing fees with the court. You may be required to post a bond. Of course, creditors are gonna come in and put in their claims. So that all has to be handled if there's creditors of the estate. And then finally, if the person who died ever got Medicaid benefits, then there's the potential of Medicaid estate recovery that we have to deal with. So this all happens in the context of this succession probate process. And this is why a lot of people choose to avoid that by doing a trust instead of a will, because a trust avoids probate. So I'm not saying a trust is right for everyone, but if you have the kind of financial picture where a trust is recommended, it's going to help you avoid probate so that your heirs won't have to file anything in court. Everything will be kept private, and it'll be really, really easy to administer that trust rather than open a succession. When you create a revocable living trust, I have this picture of this treasure chest with the lid open. While you're alive, that's exactly what it is. The trust is open. You can go in and out of it anytime you want. You're the trustee, you're the beneficiary, you're the owner of this trust. So when we create it, we actually give you the documents, you sign them, and then we retitle all of your assets into the trust. We call that funding. So investment accounts go into the trust, bank accounts go into the trust, your house goes into the trust, any stocks or bonds go into the trust, any personal property you own goes into the trust. We also often will change your beneficiary designations on your life insurance and retirement accounts and have those go into the trust, just so that everything goes into one pot, and then your trustee administers it according to the terms and distributes to the beneficiaries. Again, the key benefits of the trust versus the will is that the trust does not require opening a succession, does not require probate, does not require filing anything with the court. It's all handled privately, and as a result ends up being usually a lot less expensive than a will-based plan. So, we talked a little bit about what happens without a plan. We talked about some of the 4 things you need to have a complete plan. But really what we hear is, the reason we plan is to avoid risks. So we want to protect our nest egg. We want to protect your life savings, everything you've worked for. So what are the things that can eat into that during a death or an incapacity or an illness? So we have probate costs, of course, which we already talked about. And, that could be anywhere between $3,000 and $5,000, but it can go up to like $40,000 or $50,000 depending on the case. Taxes. While the estate tax right now is not an issue, Louisiana does not have an inheritance tax, and the federal tax, the estate tax exemption is over $11 million per person. So at this point, for a lot of people, estate taxes are not a concern. If you have more than $22 million or more than $11 million, it is a concern. But assuming you don't have over $11 million of net worth, estate taxes are not an issue. What can be an issue is our income taxes. A lot of you probably have 401k plans and retirement accounts, and while those accounts are great because they allow you to grow your investments tax-free, at some point you got to start taking the money out and you have to pay taxes. Also, your heirs, when they take that money out, will have to pay taxes. So that's something that we try to plan for in your estate plan. And then finally, nursing home costs. And nursing home costs, I would argue, are probably the biggest impact on most people because, like I said, most people don't have an estate tax anymore. There may be income tax consequences to some retirement accounts, but nursing home costs ends up being like a huge chunk of what ends up eating up your life savings. So is this even an issue for you? Like, how likely is it that you're going to need nursing home care? So I have a few statistics from different sources. So Genworth Insurance publishes some data. The Department of Health and Human Services also publishes data. So the latest data, which I believe is from 2019, is that at least 1 out of 2 people will need some type of long-term care from some period of time. Now, if you're over 70, of course, your odds of needing long-term care go up dramatically because according to the Department of Health and Human Services, 70% of all people over age 65 will need some type of long-term care. So that's the bottom line is you're probably going to need long-term care. What we don't know is how much, right? And how much does long-term care cost here in Baton Rouge? So I checked some statistics. And so assisted living on average is about $3,600 a month. And then actual nursing home care is $5,800 a month average. Now, I've seen prices anywhere between $5,500 to $7,500. It just depends, which nursing home you go to, how nice it is, whether you have a private room. So there's other factors that may make this number higher or lower for you. Very few are lower than, I haven't seen any less than like $5,500 a month. So that's kind of what you're looking at in terms of costs. And as you can imagine, that adds up fast. So even if you're only in the nursing home for 3 years, you're already talking about $210,000. So how do you pay for it? There's really 3 main ways people pay for this. If you're lucky that you've accumulated a large estate and you have plenty of money in savings, you can just pay for it out of your savings and just pay privately for care. And the great thing about that is you can do whatever you want. You can do assisted living, you can have someone come to your house and just pay for home health, you could go move into the fanciest nursing home in town. you have more control if you're able to use your personal savings. A lot of people buy long-term care insurance, and so long-term care insurance can also be great because it also gives you a lot of flexibility of what type of care you can buy. You can do assisted living, you can do home health. You have to look at the terms of your policy, and that's something that we sometimes help our clients with, is reviewing that and evaluating it. But yeah, a long-term care insurance policy, if you qualify for it, is a great way to plan for your long-term care. The only bad thing about trying to get a long-term care policy is that you have to buy it when you're young enough that you're still healthy. Because if they see any kind of medical issues in your medical history, they will not give you long-term care insurance. So it can be hard to get. So, I mean, most people that are like over 55, 60, that's a good time to kind of start shopping for it and see if it makes sense for you. And then finally, if you don't have insurance and you don't have enough savings, you can qualify for Medicaid benefits to cover your long-term care. Generally, to qualify for Medicaid, you have to prove that you don't have very many assets. The rules are really strict. If you're a single person, you're allowed to keep about $2,000 of cash, of countable assets. If you're married, you can keep a little more because there's a spousal allowance, but still we're talking, the spousal allowance is like 138. So it's not a lot of money. So if you have to qualify for Medicaid, you basically have to restructure your finances so that the assets that you do keep aren't counted. Now, not everything is counted. So, for example, they allow you to keep one car. If your spouse lives in the house, they allow you to keep the house. If you have a disabled child living in the house, you're allowed to keep the house. So there's all these rules about what's countable and what's not, but the general rule is $2,000. So as you can imagine, that means that if you have some money put away, say you have $500,000 in the bank, and you're looking at possibly needing a 3 to 5 year nursing home stay, I mean, that will basically use up your entire estate, and there'll be nothing left to pass to your kids and nothing left after it's gone. So a lot of people don't like that outcome. So what we can do actually is we can look at your finances and we can create what I like to call it like your family savings protection plan, asset protection plan. So if you plan ahead, you can actually protect your home, your life savings, and your investments. Plus, while you're at it, make things easy for your family. What we want to avoid is we don't want to run out of money, because that's not good. You don't want to leave the family home unprotected. This is one of the things that most people who come to see me, that's one of the things they're most worried about, is how do I protect the family home? I don't want Medicaid to come back and take it after I'm gone. I want it to stay in the family. And the third thing is risking the health of family or spousal caregivers. As caring for an elderly person is not an easy job, and it causes a lot of stress, and it really affects the quality of life of the people that are taking care of you. And so what most people want is to come up with some kind of plan where they can make sure they're going to have some money put away, make sure they're going to be able to protect their house, and make sure that whoever is caring for them has the funds available to get support. So what that can look like is having a home health person come so many days a week, things like that we can do to make life easier for those caregivers. So the easiest way to explain this, just to give you an example. So I have here Mary. Mary's 78 years old. She recently lost her husband after a long battle with cancer. Her family wants to make sure that she's going to be taken care of in case her health fails. She has 2 kids that live out of state, and they worry about her living alone. She owns her home, and she has about $225,000 in savings, checking, and CDs. And she has a long-term care policy that she's had for like 20 years. It only pays a daily benefit of $75, which most nursing homes charge about $210 a day. So it's not quite enough to cover all her care. So just to summarize, she has a home. Her home's worth $300,000. It's paid off. She has $225 in savings and CDs, and she has this long-term care policy for $75 a month. So if we're going to create a plan for her, here's what that could look like. So we could take $50,000 in cash and put it in a revocable living trust. That way it'll avoid probate. she can have access to that money as she needs it, and that's kind of money that she can just keep for herself for her own needs. Alternatively, she could just leave that in her checking account if she's not worried about probate. Um, she has long-term care policy, and we recommend that she keep it because that helps to pay for some of her care. And then she has her home and the rest of the cash, which is $175,000. So what we normally do if we have a situation like Mary's where she's healthy now, but we don't know what's going to happen in the future, we can actually put that money into a special trust, and we call it the Family Asset Protection Trust. Notice how this trust has a lock on it. That means that once Mary puts her assets in there, she cannot get them out. I'm going to explain how all that works, but in order for it to be protected, she has to give up control of those assets. So she puts the assets in that trust. So now we have some money in there. And then while we're at it, we're going to create some really great enhanced powers of attorney to make sure that Mary has specific powers to give to her children or the people that she trusts to handle her medical decisions and her financial decisions if something happens to her. So that's going to help us manage Mary's care and finances if Mary becomes unable to do it on her own. So great thing about this plan, it protects almost $500,000 of her assets, because now when she runs out of the $50,000, as long as we make it 5 years past the day we create this trust, she'll be able to apply for Medicaid and get it right away. So the 3 key benefits of her plan is that she has long-term care, so she has that, and she has her own fund. So if she needs an issue, she has an issue that comes up, she has some money that she can access, and she has some benefits and that she can take from the policy, and the money that she put in that Family Asset Protection Trust, even though she doesn't have access, her kids do. So that means that if she needs money for something, her kids can always pull money out of that trust to help pay for it. So after 5 years, all the assets in that family trust would be protected and would not be counted for Medicaid purposes. So if Mary needs to apply for Medicaid 5 years from now, that money in that trust is protected. It's out of her estate, and Medicaid can't take it into account in counting her assets. So she would be able to get Medicaid. And if she becomes unable to make decisions for herself, the financial and healthcare agents that she appointed in those powers of attorney will step in and make those decisions for her. So let's talk a little bit more about that family asset protection works and the 5 years and all of that, because I'm sure you all have questions about that. So Medicaid has this rule that you can't give away your assets to qualify for Medicaid. Which makes sense, right? Because otherwise everybody would just give everything away, apply for Medicaid tomorrow, and we're done. So what Congress did several years ago, back in like 2015, is they changed the rules. So you can actually give money away, but if you try to apply for Medicaid within 5 years of the date you gave those gifts, then you have to report those gifts, and those gifts are counted against you for purposes of qualifying for Medicaid. So they'll impose a penalty. The penalty basically is a delay. So for example, if you gave a $50,000 gift, Medicaid would say, okay, that gift disqualifies you, so we're not going to cover you for 10 months, because they divide the gift by $5,000 a month. So for 10 months, you're going to have to pay for your own care. After 10 months, we'll cover you. So that's why it's important that we do this kind of planning before mom ever needs the nursing home, because if we wait, we may run into that 5-year period, right? So the way the family trust works is, it's a box, it's locked. So Mary's assets go into the trust. So we put her house, we put some cash in there. And generally, the house is usually a no-brainer. Most people want to put their house in. With respect to how much cash we put in, that really depends on you. So some people are more aggressive and want to put more in, and some people want to keep more money in cash for themselves. And so they're like, you know what, I'm just going to put a little bit in there. But that's totally up to you. We can talk about, the risk benefits and help you figure out how much to fund into the trust. Once you have the trust created, like I said, it's a locked treasure chest, so you can no longer access it. You created the trust with your assets, so you are considered the owner of the trust, but you're not a beneficiary, you can't be a trustee. And you can't take any income or anything out of the trust. The only beneficiaries of the trust have to be other people. And most people name their children as beneficiaries. For trustees, we can either name one of the children, or even better, we can name somebody independent, like a family friend or another relative, or somebody that you trust to handle the trust administration of the trust. Your kids are beneficiaries. So after 5 years, mom can qualify for Medicaid, and the children can actually use the assets from the trust to help take care of mom. Because what happens when you go on Medicaid? You have no money left in your bank account, right? You will have had to spend anything that you kept out of the trust. You're allowed to keep $2,000 in the bank. So Medicaid covers your nursing home, but there's probably other things you're going to need: clothes, entertainment. Maybe you want an upgrade to a private room rather than a shared room. All of these things that cost extra that are not covered by Medicaid, your children can kind of provide for you. They can take money out of the trust and they can help pay for your care that way. So that's kind of how we do it, and that's how we're able to protect the assets and still take care of you and control everything financially, so that Medicaid will not count the money in the trust as your assets, and then you'll be able to get those benefits. So I know this could be a little bit confusing, so I'll just explain again. Revocable trust, open treasure chest, family asset protection trust, closed treasure chest. The revocable trust stays open. The revocable trust assets do count when Medicaid looks at your assets. So if you have more than $2,000 in one of these trusts at the time you apply for Medicaid, you will not qualify, right? So this is money that you have total control over during your life. The family asset protection trust, you put it in there and you lock it. So at that point, you lose control of that money, but it also gets protected from Medicaid. So if Mary didn't do the plan, then technically she would have to go through the $525,000 of assets before she qualified. Now let's talk about the house. So Medicaid will let her keep the house. So they will keep she can keep the $300,000 house, right? So then she has to spend the rest of the money, the $225,000. The problem is when Mary eventually passes away, Medicaid can take a claim against that house because they have what's known as Medicaid estate recovery. So because they gave her care and let her keep the asset, they reserve the right after Mary passes away to come back and file a claim in the estate for whatever they spent on Mary's care. So if Mary ended up staying in the nursing home for 7-8 years, then the house is going to be gone, because once Medicaid files that claim, they're going to be able to get paid out of the house, put a lien on the house and either force a sale or get paid through the succession process. So in effect, the whole 525 could be consumed by long-term care costs. It's not a guarantee. Medicaid doesn't always go after the house, but more and more they're starting to get a little more aggressive with budget cuts and everything that's going on. So if you want to protect your house, you have to do something like this kind of trust. If Mary didn't have the power of attorney, then her kids would have had to appoint a curator for her once she became incapacitated in order to get power over her finances and her medical decisions. A typical interdiction proceeding could cost $5,000 to $10,000. It's really not an ideal situation. If we don't do any planning, once Mary spends down all of her assets, she might be able to keep the house, but that doesn't allow her to spend money on things. So if there's no funds put away in a little trust somewhere, then there's not going to be any money for the kids to supplement Mary's care. So they would have to pay for that on their own. And it's possible that nothing goes to them upon her death because her entire estate has been spent on paying for Medicaid. And her choices would be limited, because if you go into Medicaid nursing home coverage, the only thing they cover really is nursing home. They do have a waiver program for assisted living and home health, but those waiver programs have a huge waiting list, and at this point, it's really hard to get into those. So most people who are applying for Medicaid are doing it in the context of just nursing home care, which may not be the ideal care that you want. So like we said, we were able to protect $475,000 of Mary's assets by creating this plan. And so I know a lot of people wonder, like, what does it cost to do this? And And it is expensive because it is complicated. So what I want you to focus on is not how much it costs. Mary's particular plan would have cost $6,000 because we created a revocable trust, an irrevocable asset protection trust. We created the powers of attorney. We helped her with all her asset transfers, and all of that cost $6,000. But by spending that $6,000, Mary was able to protect $475,000. So if you look at it that way, it actually saved her money to do the planning. And honestly, the goal that most people have is, everybody wants to age with dignity. Nobody wants to end up in the worst nursing home in town with, a bad situation like that. And so the goal is to ensure the best access, the best care possible for you, and to have someone appointed who can take control, and you can control who the person is who's going to manage your finances for you if you need that done because you're incapacitated, and you can set those rules if you plan ahead. And then you can also leave your home and savings to the people you choose, so you don't have to take a chance that the home is going to be subject to a Medicaid recovery claim. You don't have to take a chance that nothing will be left by the time you pass away. Excuse me. So how does this work? So our plan to create one of these family savings protection plans, it's a 3-step process. So it's a series of meetings that we have where we meet with you to review everything. We review your situation, we present recommendations, and during that meeting, and that meeting is complimentary. It's just a chance for us to learn more about you, look over your situation, and kind of give you some ideas of what we can do. Assuming that meeting you decide to move forward, then it takes us about 4 weeks to put all of your documents together for your plan. So we have a signing meeting where everything gets put into effect. And then a few weeks later, we have a final meeting, and this is where we will deliver your final documents, have a talk to your trustee, make sure your trustee understands how to handle the trust, assist you with asset transfers, and just finalize everything in your asset protection plan. So start to finish, probably like the fastest we've ever done one is about 6 weeks, and the longest we've done one is about 12 weeks. A lot of it depends, on your schedule and how busy we are in the practice, in the law firm. So I've explained the importance of long-term care and how to put a plan in place. And now you get to decide what to do next. So you could just put it off, like a lot of people put off estate planning. But you just have to think about that you're leaving your family at risk from high cost of long-term care. You're leaving the family home unprotected. There's nothing wrong with that if that's not important to you. If you don't care if your kids get your assets after you're gone, then you don't have to worry about this. If you're not worried about, if you don't think you're going to need long-term care because you're super healthy, then maybe you don't want to worry about this. But estate planning in general does so much for the peace of mind of you and your family that it's really good to go ahead and take care of it. Or you could take action and you could proactively plan. So by proactively planning, you can make sure that you leave your legacy to the people you want. You can ensure that you're going to have access to the best care possible, and you can take control over who will manage your finances if you're unable to, and under what circumstances. So in order to help you out with that, we're giving you a $250 golden ticket. It's a gift certificate for $250 off your family savings protection plan. So all you have to do is schedule your family wealth planning session with Brittany, and she'll give you a gift certificate to bring to your meeting, and we will take that off your total fee. The fees, I gave the example of $6,000 for Mary, but really, honestly, depending on what you need, some people just need a very basic will and they're not worried about long-term care. Some people want everything with all the bells and whistles. I mean, the range for a married couple is anywhere from $2,000 to about $8,000. So Mary's ended up at $6,000, just to give you a ballpark, because she had 2 trusts plus everything else. So just to give you an idea of what fees might be. The family wealth planning session is the first meeting, so this is what we want you to go ahead and schedule with us. I will send you a questionnaire ahead of time where I'll ask you some questions. For the Medicaid planning, it's super important that I have accurate information about income and assets because a lot of what's going to determine what you qualify for is exactly those income and assets. And if you don't give me that information, then I can use some averages. It's just better planning if you fill that out ahead of time. So it's really important that you fill that out. When we meet, we'll talk about everything that's in your questionnaire. You'll get to ask questions. I'll explain the process, and I'll start to give you some ideas of what this might look like. I'll propose like what our next step is, which will usually be to put together a plan with certain trusts in it. And then at that point, you can decide, how you want to move forward. I'll give you the benefits and the pros and cons of each of the different options, and it's really up to you, what's right for your family. If you decide you want to move forward, we'll sign an engagement letter that day. You'll pay a deposit, and we'll get started on your documents. So if you want to move forward, please see Brittany in the back of the room to book a time for your consultation. If you're watching this presentation virtually, there will be a link under this video where you can actually click and schedule a time for your consultation, or you can always call our office at 225-465-1090. Thank you so much for attending, and if you have any questions, I'm happy to take them now.